Okay, we'll bring to order the meeting the Public Safety and Security Policy and Finance Committee and start out with the roll call.
Representative Cornish.
Here.
Representative Johnson. Here. Representative Hillstrom.
Here.
Representative Becker-Finn.
Here.
Representative Considine.
Here.
Representative Dean.
Here.
Representative Frankie.
Here.
Representative Grossel.
Here.
Representative Howe. Representative Lomer.
Here.
Representative Lucero.
Here.
Representative Newberger.
Ready to serve.
Representative O'Neill.
I'm here.
Representative Pinto. Representative Ward.
Here.
Representative Zerwas.
Here.
Okay, we'll start out with the approval of the minutes motion for March 23rd. Anyone want to move the minutes? Representative Newberger moves the minutes for March 23rd. All in favor say aye.
Aye.
Aye. Opposed? Okay, we'll start out with the House File 238. The chair will move House File 238. We refer to the General Register and explain that since it's past deadline, by rule, the chief clerk will send that to rules after that as amended. So chair will move House File 238 in front of us as amended. We won't be taking public testimony today, but we will, and we have no amendments, so we'll start out with member questions.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. Is the author of the bill here, or who is
No.
taking questions? Mr. Chair, the question that I have is the governor has previously vetoed this bill. We actually have the veto letter from the governor previously. The question is, what is different in this bill compared to when the governor vetoed it last time that causes you to believe there would be any different outcome?
I don't believe anything. Representative Lucero.
Thank you, Mr. Chair, and I would like to call the roll. I think it's very important that we know, or the public knows, who's going to be on the side of individual liberty and who is not going to stand on the side of individual liberty. So, Mr. Chair, I request a roll call.
Okay, so noted. Representative Lucero asked for a roll call. Other questions? Representative Hillstrom.
Thank you, Mr. Chair. This one won't necessarily just be a question, it will be a statement. So, members, March 5th of 2012, the governor sent a letter stating why he was vetoing the letter. I don't see that there's anything different in this bill that would change that. We also have heard previous testimony on March 7th of 2017 from the County Attorneys Association about how they believe that this change is problematic. Members, you all have all received a copy of that letter. I do not believe that this is in the best interest of Minnesotans, and I would encourage members to vote no.
And it should be noted, over the last few years, the governor has sent all sorts of letters out threatening vetoes. Any other questions? Okay, with no more questions, the chair will move House File 238 as amended to go to the General Register, and with the roll call.
Representative Cornish.
Aye.
Representative Johnson.
Aye.
Representative Hillstrom.
No.
Representative Becker-Finn.
No.
Representative Considine.
No.
Representative Dean.
No.
Representative Frankie.
No.
Representative Grossel.
Aye.
Representative Howe.
Aye.
Representative Lomer.
Yes.
Representative Lucero.
Yes.
Representative Newberger.
Aye.
Representative O'Neill.
Yes.
Representative Pinto. Representative Ward.
No.
Representative Zerwas.
Aye.
Okay, there being 9 ayes, 6 nays, and pass. The motion carries, and the bill is referred to the General Register. Okay, that's all we have for gun bills. House File 896. The chair will move House File 896 to be referred to Ways and Means as amended. Amendment? Okay, I'm going to take amendments first, and then public testimony from a few of those that have signed up. And we're not going to take public testimony unless it's something new language. Okay, the author's amendment is House File A32. The chair will move House File A32 to get the bill in shape the author would like. All in favor say aye. Aye. Opposed? Okay, there was a mistake in the spreadsheet that added too much for district judge compensation, so the mistaken amount is going to be subtracted from the judges and allocated as described below. This amendment adds an additional $184,000 from the fire safety account to main ERT in St. Paul, in addition to St. Cloud, Duluth, and Moorhead, and includes $250,000 to fund the second year of the anti-terrorism program grants, bringing the biennial total to $500,000. An additional $119,000 is included in the first year of the biennium for sex trafficking grants, bringing the biennial total to $479,000. $100,000 each year for an outreach officer at the post board. This request was included at the governor's recommendations. An additional $30,000 per year for Representative O'Neill's technical probation violation, House File 2176, bringing the yearly funding to $85,000 for the pilot program grants. And inserts Representative Erdahl's House File 380, increasing the fines from $300 to $500 for failing to stop for a school bus stop arm. Any questions from members? Okay. I've already moved it. Other amendments?
So, Mr. Chair, are you adopting the A32 amendment?
Yes.
We need to vote on, did we vote on it?
Yes.
Okay, all right. Mr. Chair, I have the A1 amendment. Mr. Chair, the A1 amendment prohibits the use of the Appleton prison. It strikes the language in the bill, and it bans the Appleton prison here in Minnesota. It specifically prohibits the use of private prisons in Minnesota. And, Mr. Chair, I would ask for a roll call.
Okay. Representative Hillstrom moves the A1 amendment and asks for a roll call. Any questions from members? If not, the clerk will take the roll.
Representative Cornish.
No.
Representative Johnson. Representative Hillstrom.
Aye.
Representative Becker Finn.
Aye.
Representative Considine.
Yes.
Representative Dean.
Yes.
Representative Frankie.
Yes.
Representative Grossel. Representative Howe.
Nay.
Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill.
No.
Representative Pinto. Representative Ward.
Yes.
Representative Zerwas.
No.
Okay, there being 6 ayes and 9 nays, the motion fails. Next amendment, A4, Representative Pinto.
Mr. Chair, Representative Pinto had a constituent issue over in the Capitol. He will be here momentarily. If we could pass Representative Pinto's amendments and come back.
A4, 5, and 7 pass.
If we could pass those until he gets here, I
Okay.
would like to offer the A8 amendment.
Representative Hillstrom offers the A8 amendment. Go ahead, Representative Hillstrom.
5 and 7.
Thank you, Mr. Chair. Mr. Chair, the A8 amendment goes directly to the funding of the 38 public defenders that were requested in the governor's budget proposal. Mr. Chair, throughout this bill, there are enhanced penalties, there are additional criminal new crimes that are created. It will result in additional work for the public defenders. The public defender's office is already strapped. Their caseloads are higher than the national average. Mr. Chair, I understand that your budget target did not permit the funding of that. However, there is additional funding available through the MinCore fund. Mr. Chair, you currently took $2 million from that fund, and that is where I have funded the public defenders, 38 additional public defenders, Mr. Chair.
Okay, thank you, Representative Hillstrom. Somebody from the Department of Corrections, MinCore around?
Commissioner.
Anybody? Commissioner, why don't you come down and tell us what you think about the amendment and MinCore funds and the balance, what you're going to use it for and how it would affect the plan, and ours as well.
Mr. Chair, committee members, good morning.
Mr. Chair, specifically the question is to comment on the use of MinCore funds to support this initiative.
Exactly, wherever the amendment comes from, either side, what your testimony is on taking money from MinCore and how much and how it affects your mission of MinCore.
Thank you, Mr. Chair. Committee members, Representative Hillstrom. MinCore operates as a standalone business, authorized specifically by statute. Typically, the use of profits from that corporation go to support services for inmates and to enhance MinCore operations and infrastructure. Just like any other agency or corporation, there are significant needs to maintain that corporation. We have within the department, as you know, many internal needs, and at some point today I will comment about some of those other needs. I would prefer not to comment on the validity of this amendment or its need as a standalone need, but only tell you that the Department of Corrections has multi-million dollars of needs, and in the past, this committee has accessed some of those MinCore funds, and we see that as payback to the general fund for your support, and I think that concludes my comments.
Okay, member questions, Representative Hillstrom.
Thank you, Mr. Chair. And Commissioner, I appreciate your testimony. If this amendment fails, I have another one to fund your correction officers out of this same MinCore fund. Members, throughout the history of this committee, many times we get a target that doesn't fund the need for public safety. And this fund has historically been tapped when necessary, and usually we attempt to get the dollars back if possible. It is never ideal to have money that you take that doesn't roll it into the base when you're hiring staff. This would fund these these public defenders for 2 years, and my hope would be that between now and 2 years from now, there would be an election, and there may be a different chair or a different philosophy that comes forward in the next budget cycle. So with that, members, I would ask for a roll call vote on the A8 amendment and encourage your support.
Okay, any questions? Seeing none, the clerk will take the roll in the vote.
Representative Cornish.
No.
Representative Johnson. Representative Hillstrom.
Aye.
Representative Becker-Finn.
Aye.
Representative Considine.
Aye.
Representative Dean.
Yes.
Representative Frankie.
No.
Representative Grossel.
No.
Representative Howe.
Nay.
Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill.
No.
Representative Pinto.
Yes.
Representative Ward.
Yes.
Representative Zerwas.
No.
Okay, the vote being 6 aye and 10 nay, the motion fails. Representative Pinto, you want to run through yours now?
Yes. Thank you, Mr. Chair. My apologies. Yes. And which amendment?
A4, 5, and 7 you have listed here.
Thank you, Mr. Chair. And Mr. Chair, so the A4 amendment, taking that one, is deleting the section of the bill that relates to the Sentencing Guidelines Commission. So the provision, members, just to remind you, requires that when the Sentencing Guidelines Commission makes a decision regarding, makes a recommendation regarding a sentencing guidelines change, the bill would now require that change to receive affirmative approval from the legislature before that change can be enacted. That would include minor changes. The Guidelines Commission is continually making corrections to things and changes, fixes based on statutory changes that we've made. Right now, and I think we talked about this at the time, the legislature has complete control over whether a Guidelines Commission recommendation goes forward or gets rejected, but we do need to act affirmatively. I'm very concerned about the language of the bill, that it would hamstring the Guidelines Commission unnecessarily and really prevent it from doing its work. Again, if we have concerns with something that's going to be done by the Commission, we can certainly act to do so. So, Mr. Chair, I would urge the committee to approve the A4, which would delete that section and simply return us to the circumstances which we're under at this point.
Okay, the Representative Pinto moves the A4 amendment. Any questions? Representative Dean?
Thank you, Mr. Chair. So one of the things that concerns me about this, removing this or not including this in the omnibus bill is we're now beginning to politicize a system that we put in place that, quite frankly, has been a system that has worked really, really well. And we've kept the partisan politics out of the process, and we've been able to negotiate this. And, you know, as we begin to see more and more of these things that I believe are going to be legislative oversight, I think we're moving towards starting to have a conversation about being a full-time legislature. Because if we're going to manage every little thing that every department does or what every agency does, there's no way we're going to be able to get our work done in the period that we have for session. So I would ask that members support Representative Pinto's amendment.
The chair thinks the sentencing guidelines has gone off the track and would ask for a no vote. Okay, all in favor say aye.
Aye.
Oppose? No. Motion fails. All right, Representative Pinto, A5.
Mr. Chair, I'm withdrawing the A5 amendment.
A7?
And Mr. Chair, the A7 amendment, Mr. Chair, one moment, please, increases, there was a funding request, as members are aware, regarding, I'm sorry, Mr. Chair, I'm looking for the A7 in my packet. Oh, do you have that? Okay. Okay, thanks. Yeah, I have it. Thank you. The bill provides for some increased funding for anti-terrorism efforts. We will recall that the Faribault Police Chief had brought some information regarding that to our attention, and it seems to me, Mr. Chair, that it's a good idea and that we should provide some additional funding for it. And as members will see at line 1.3, it does that. And then what it does is then removes the provision that relates to the operation of the privately owned prison and the purchase of that on page 14, line 3. That's in line 1.4. This provides the funding from that.
Okay, Representative Pinto will move the A7 amendment. Any questions? Did he ask for roll call? All in favor say
And Mr.
aye.
Mr. Chair, if I can ask for my apology, ask for a roll call.
Sure.
Thank you.
Roll call is being requested. The clerk will take the roll.
Representative Cornish.
No.
Representative Johnson.
No.
Representative Hillstrom.
Aye.
Representative Becker-Finn.
Aye.
Representative Considine.
Aye.
Representative Dean.
Yes.
Representative Frankie.
No.
Representative Grossel.
No.
Representative Howe. Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill.
No.
Representative Pinto.
Yes.
Representative Ward.
Yes.
Representative Zerwas.
No.
Okay, there being 6 ayes and 10 nays, the motion fails. Do you want to do the A29, is it? Oh,
And Mr.
okay, wait. Well, I guess we're going to do them in order. Representative Pinto, we'll come back.
Thank you, Mr. Chair.
Thank you. Representative Dean, the A9 amendment?
Yes, thank you, Mr. Chair. What this does is it actually restores the transfer of the community reinvestment account and takes the money from MinCor. And I know that we're going to be talking a lot about MinCor, but when we look at issues around justice reinvestment, I think it's critical that we fund that at the level that, one, it needs to be funded, and ultimately we begin to address the issues around incarceration in our state on the front end. Far too long we've invested on the back end, and we continue to consider investing on the back end, and I think that in the end we're going to have more bang for our buck. And I know that some of the MinCor funds are used for services for inmates, but it's my personal belief that we shouldn't be funding services for inmates out of enterprise systems that we have. That should actually be part of the general fund. Ultimately, we have a responsibility to make sure that those individuals that we lock up get the services and the education, in the training, so that when they come out, they're less likely to recidivate and reoffend. So I'd like to move this forward, and I would like to actually, well, I don't know, I have a feeling the way this is going to go with the chair, but I won't do a roll call.
Okay, Representative Dean moves the A9 amendment. Any questions? Seeing none, all in, Representative O'Neill, go ahead.
Sorry, Mr. Chair. I appreciate what you're trying to do here, Representative Dean, and you and I share that same passion and that same hope that we can kind of help them on the front end. But you know that this is, and I am adding this because you didn't, but it's part of the sentencing reform that we had done last time, and we did see a drop in prisoners, but it's hard to actualize that and to actually quantify that. So I know the department will be moving forward and putting more money. They'll be explaining a little bit better about the cost savings that we've had with the drop in prisoners. And so that's coming, and I just wanted to get that on the record that, I personally am very supportive of the concept, but the money hasn't been really actualized yet. We have to figure out how much we've actually saved. And so it takes a little bit of time to kind of crunch those numbers, but thank you for the amendment.
Any other questions? All in favor of the A9 amendment, say aye.
Aye.
Opposed? No. Motion fails. The A11 amendment, Representative Becker-Finn.
Thank you, Mr. Chair. So this amendment would remove the sections that increase the penalties for protesters and those who obstruct roads and transit. Members, we heard from many members of the public who are against this bill, and it is my belief that this language was introduced in the spirit of silencing dissent. As a strong believer in the First Amendment of the Constitution, I think the removal of this language would actually make this a better bill, and would be happy to work with members on both sides of the aisle going forward to kind of address the underlying injustice that really has led to this dissent and the increase in protests. So happy to take any questions.
Representative Zerwas.
Thank you, Mr. Chair. Thank you, members. I feel confident with the language that we've included in this bill. This is compromised language that came out of the Senate hearing, and this is language that the governor has indicated repeatedly that he'd be open to considering signing. So I don't think there's a need to remove this language.
Mr. Chair.
Okay, Representative Hillstrom.
Thank you, Mr. Chair. Representative Zerwas, I have seen the news where the governor said that he would be open to addressing the issue of freeways and airports, but I hadn't heard him address the issue of transit. And I would notice that in this bill, you have included the language about blocking the light rail and blocking bus transit. So do you have an indication that the governor would support those two pieces?
Representative Zerwas.
Mr. Chair, members, so I've seen the same news reports that you have where he pretty blatantly said he wouldn't support civil penalties but would support increased criminal penalties. And then he said in narrow circumstances, and he said like freeways and the airport, he didn't discount including mass transit or trains. I've had 2 requests into the governor's office to ask him about his support on this bill. We've never received a response back from the governor's office, but he certainly has not conveyed to me in any shape or form that it's language he would be unwilling to sign.
And let's see here. Representative Pinto.
Thank you, Mr. Chair. Yeah, I want to just zero in on the transit language, too, just pointing out, and I think we did before, that somebody who restricts passenger access to the transit vehicle, I mean, let's be clear, we're not just talking about, blocking lines or being in the road in front of a bus. I mean, if somebody blocks somebody from walking into the door, open doors of a light rail car, that's increasing the penalty on that. The transit provision especially is really, really broad, and increasing it from misdemeanor to a gross misdemeanor, and reminding ourselves that misdemeanor domestic assault can be a pretty bad set of injuries, actually, and this is something that's going to increase these penalties to a gross misdemeanor. So I'd certainly urge members to support the amendment, and this seems like this needs quite a bit more work.
Mr. Chairman.
Representative Pinto, What do you think of County Attorney Choi's decision-making process if this is, if he has the availability to charge these people? Do you think he's smart enough to tell who should be charged and who shouldn't?
Mr. Chair, County Attorney Choi would not be charging this because it's a misdemeanor versus gross misdemeanor, and he would just charge a felony. And I guess if you're asking whether prosecutors can be trusted to use good discretion, I think in many cases they can, although of course we could then just have our criminal laws just say they can charge anybody with anything. So I think that having a framework that sets up crimes with the appropriate punishment, it seems to me that what's described here regarding transit operations, we needs a lot more work before we be increasing penalties for it.
That's why we're trying to help out Mr. Choi, give him a good framework. Representative Zerwas.
Mr. Chair and members, in existing statute already, it's already a felony to block access to mass transit with the use of force or violence. And so this is just saying that if you do a human blockade to block a train or block access to a train or a bus, to move that from a misdemeanor to a gross misdemeanor. People rely on this to get home, to get to work, to get to events. We just want to make sure that the buses and trains run on time.
Okay, any other questions? If not, yeah, oh, I'm sorry,
I
Representative Beckerfield.
request a roll call.
Okay, Representative Beckerfield requests a roll call. The clerk will take the roll.
Representative Cornish.
No.
Representative Johnson.
No.
Representative Hillstrom.
Aye.
Representative Beckerfin.
Aye.
Representative Considine.
Aye.
Representative Dean.
Yes.
Representative Frankie.
No.
Representative Grossel.
No.
Representative Howe.
Nay.
Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill.
No.
Representative Pinto.
Yes.
Representative Ward.
Yes.
Representative Zerwas.
Nope.
It being 6 ayes and 10 nays, the motion fails. A12, Representative Lunan.
I believe that's my amendment, Mr. Chair.
Oh, excuse me. Lunan, I got his name, but he's the author, the author of the amendment, A12, Representative Hillstrom.
Thank you, Mr. Chair. Mr. Chair, I have a page passing out, handout for folks to see regarding this issue. Members, what this amendment does is it takes out or repeals the language. It takes out the repeal of the language of the seatbelt gag rule. Currently, a jury is not permitted to hear whether or not a victim in a crash or the person who had the injury, whether or not they were wearing a seatbelt. And there's been a long public policy about not permitting juries to hear that information because if you were injured in a crash and it's not your fault, whether or not you were wearing a seatbelt is not relevant in whether or not they're determining who's responsible for the crash. Members, you have a handout that's being passed out about the charges that are likely against the semi-driver who allegedly hit the cab at the St. Cloud light that killed 2 people. This is the very example. If someone is stopped at a light and someone does something wrong which causes injury to them or death, and they've done nothing wrong, whether or not they were wearing a seatbelt is not something that the jury should hear. We prohibit juries from hearing other pieces of information as well. For example, the jury doesn't get to hear whether the semi-driver has insurance on his vehicle in determining whether or not the driver was at fault or what the payout should be. Members, the bill that we have in this bill that allows juries to hear about the seatbelt costs an entire judge unit. That's what it costs. Why does it cost an entire judge unit? Because more insurance companies will be taking these cases to court so they pay victims less. The provision in the bill incentivizes insurance companies to fight about how much victims should be paid when it comes to the injuries that they have suffered. And we have seen all across this state and country incidences where someone causes harm to someone else and they either don't have enough insurance or they don't want to take responsibility, and victims ultimately end up paying the price. I don't believe that we should be incentivizing people who commit criminal acts. I don't believe we should be giving folks who drive drunk and harm someone an incentive to fight in the courtroom. And members, we've seen the statistics all across this country. When states have cases like this, there are more cases that go to trial. There are more cases that are fought, and that is why the fiscal note is very expensive and says it will cost an entire judge unit. The judiciary has already said that they are short judges. They asked for 2 judges. So my amendment deletes the language about the seatbelts, the seatbelt gag rule, and allows the judiciary to keep the money for the judge unit that they already said they needed. Otherwise, what you have is a system that is already underfunded. I would ask that members vote to take out the seatbelt, the elimination of the seatbelt gag rule.
The chair would note that Representative Luna not being here, this doesn't make an automatic decision. What it does is allow another piece of evidence to be entered in for the jury to consider. And so the chair would ask for a no vote on the amendment. Any other questions? Did you ask for a roll call? Okay. All in favor say aye.
Aye.
Opposed? No. No. Motion fails. Okay. Representative Hillstrom, A13.
Thank you, Mr. Chair. Mr. Chair, the A13 amendment once again taps the MNCOR fund. We know, let's see, A13, we know that there is an underfunding of probation officers in this bill based on the target that we received. This bill, this amendment fully funds the request that they've made for probation officers, and it funds the money out of MNCOR. I would ask members to vote yes, and Mr. Chair, I would ask for a roll call.
Okay, Representative Hillstrom moves the A13 amendment and asks for a roll call. Any questions? Seeing none, clerk will take the roll.
Representative Cornish.
No.
Representative Johnson. No. Representative Hillstrom.
Aye.
Representative Becker-Finn.
Aye.
Representative Considine.
Aye.
Representative Dean.
Aye.
Representative Frankie.
No.
Representative Grossel.
No.
Representative Howe. Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill.
No.
Representative Pinto.
Yes.
Representative Ward.
Yes.
Representative Zerwas.
No.
Okay, the vote being 6 ayes and 10 nays, the motion fails. Representative, who's got A15?
I do, Mr. Chair.
Okay, Representative Hillstrom.
Mr.
Or is
Chair,
that 14?
we need to do 14 first,
There,
and
go
then I
ahead.
have 14 and 15.
Alrighty.
So, Mr. Chair, the A14 does the same thing that the last amendment did with probation officers, except this time it's to actually fund the correctional officers. Members, the MNCOR fund is the fund that we use in the prison system for things related to inmates. This specifically takes that money and funds the necessary correctional officers to make, to keep our prisons safe, Mr. Chair. It is enough funding for this biennium to do that. And Mr. Chair, I believe that it is appropriate for us to fund correctional officers at the level that the governor has requested. Mr. Chair, I would ask for a roll call vote.
Okay, Representative Hillstrom moves the A14 amendment. Should be noted that when we go through this budget, I asked for a target, and when we put this bill together, we've got lines and lines of where we put the money, whether it's for probation officers, correction officers, sex trafficking, all the teams, the ERT teams, and so every time we take a dime from one, we have to short the other. And a great amount of time was putting in these special categories, and that's why after all this work, I'm not anxious to have the money transferred all around again into different areas without having time to think about it again. So the chair would ask for a no vote and roll call or not? You'd ask for a roll call? Okay, clerk will take the roll.
Representative Cornish.
No.
Representative Johnson.
No.
Representative Hillstrom.
Aye.
Representative Becker-Finn.
Aye.
Representative Considine.
Aye.
Representative Dean.
Yes.
Representative Frankie.
No.
Representative Grossel.
No.
Representative Howe. Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill. Representative Pinto.
Yes.
Representative Ward,
Yes.
Representative Zerwas,
Nope.
Okay, the vote being 6 ayes and 10 nays, the motion fails. Representative
Hillstrom.
Hillstrom, A15.
Thank you, Mr. Chair. Mr. Chair, the A15 amendment strikes the change in prejudgment interest. Members, every time we tweak who pays what amount of interest during the process of a court proceeding, from the beginning lawsuit has been started to the end when the judgment is finally paid, you incentivize folks to either pay or not pay in a timely fashion. Members, I am asking that we strike the A15 amendment. Members, we know that the current system that we have now doesn't have a disincentive for people to hold on to their money. We are seeing that cases are settling, and it's interesting, Mr. Chair, that we are only making the change in the bill, or this bill only makes the change when it comes to private people and the interest that they will be paid when they've been harmed. It leaves business-to-business interest the same. So when corporations are fighting with one another about who wrongfully did damage to the other, they get to keep the higher interest rate, but regular citizens, when they have to fight against large corporations, or they have to fight against insurance companies, or they have to fight against someone who is much larger than them, they do not get the benefit of the same benefit of interest as a business or a corporation would. So, Mr. Chair, I am asking that we remove that language, the A15 amendment.
Okay, Representative Zerwas, your thoughts?
Thank you, Mr. Chair. Members, remember that Minnesota is now becoming an outlier as 26 states have lowered their interest rates dramatically over the last several years, that in statute our interest rate is gauged off of the T-bill and then up from there, and so it's a lending rate. And then the other thing I would say, Mr. Chair and members, is that this bill has passed the House of Representatives. Last time around, it was included in this bill, and I think it'll pass again. I expect it to go to the governor.
Representative Dean.
So, Mr. Chair and Representative Zerwas, you say that we're one of 24 that do it the way we do it now, and that makes us an outlier? Could you explain what you mean by outlier? Because you mentioned 26 states, and to be like the 27th state to me doesn't make us an outlier. Could you explain that, please?
Mr. Chair.
Representative Zerwas.
Chair Cornish, Representative Dean, members, 26 states just in the last few years have lowered their interest rates. Numerous states have lower interest rates that didn't need to lower it. We're at 10% interest rate, which, if you look, does make us an outlier. There's only a handful of states that have interest rates anywhere near what we do, and I think only one or two that have it above us. We're most certainly an outlier.
Representative, was a follow-up to that, Representative Dean, and then Representative Considine.
Thank you, Mr. Chair and Representative Zerwas. When you say 26 states in the last 3 years, do you know how many of those are currently Republican legislatures that have passed that?
Representative Zerwas.
Mr. Chair, members, I do not. I can provide the list for the committee. It is not a red versus blue. This is states across the country that have realized that as the market has kept interest rates at an historic low rate for year upon year, that state statutes no longer accurately reflected what the market has been bearing out, and the changes have been made accordingly. Remember that when we went to 10% across the board, it was only 1 year later that government came back to the legislature and said, 10% is punitive and too high. We can't possibly pay 10%. Counties, cities, school boards, they said we couldn't possibly pay 10%. It's too high, it's punitive. And the legislature said, okay, we'll lower it for you. And so we do have a history of lowering the interest rate, and I think we ought to treat the little guys like we treat government.
We got a list here, Representative Considine, Hillstrom, and Pinto.
Thank you, Mr. Chair. I think we are standing up for the little guys because they're the ones that get delays after delay after delay without the interest rates being where they should be. And Representative Zerwas, if 26 of your friends jumped off a bridge, would you jump off the bridge too?
Representative, respond? Depends on the friend. Huh?
Yeah. Who knows? If you go first.
Okay, Representative Hillstrom.
Well, thank you, Mr. Chair. And so I just want to make it really, really clear what this provision in the bill does. So you've gone to court, you've been harmed, the court found that you were harmed and that you're owed money. And you have bills. And if I have bills and I don't have the money to pay them, I might have to put it on the credit card, I might have to take out a loan. And what you're saying is, accept business. They get to get their interest rate at the higher rate. But little folks, moms and pops who need to, fight against the big guys, when you win, you only get the interest at the borrowing rate, the lower rate. And most people don't get to have money loaned to them at that rate. And so ultimately, we are harming the little guy in this bill. If it wasn't, you'd also be including business as well. But business wants to keep their money.
Representative Pinto and then Lucero.
Thank you, Mr. Chair. And I guess yeah, it seems like as long as there's a distinction between business and everybody else, I don't really understand what arguments could possibly be made in favor of this in that respect. I noticed that that section 68.0811 is specifically excluded. It's on page 25. That's where the insured prevails in a claim against their insurer, businesses, et cetera. So I guess I just want to emphasize whatever other points we can make, if they're not being applied across the board, I'm not quite sure that we'd have a leg to stand on in this case. So I would urge folks to vote yes.
Representative Lucero.
Well, thank you, Mr. Chair. And if I understand what Representative Zerwas said, the current distinction, Representative Pinto, is between the government and everybody else. So we're trying to get this down to, as was said, what's good for government should be good for the private sector. And so I know, Representative Hillstrom, I'm just curious with your comments. Most of us on this, as I'm looking on the committee, are new. So when this law was passed, I'm just wondering, did you support lowering it for government? I don't even know if you were on the committee at the time.
Representative Hillstrom.
Thank you, Mr. Chair. I believe that it actually came as an amendment on the floor. And when it was government, it was really about tax assessment and about evaluations, not necessarily about lawsuits and wrongdoing. And so that is what that was related to. I believe it was Representative Mark Ward that offered the amendment on the House floor. And so you have to remember that this is when you've gone to court and you have proven that someone was harmed. So someone did wrong. And the question is, when you prove that someone did wrong to you, how much interest should you get on the money you already had to put out to take care of whatever bills you had? And I think current law is correct, and we should delete the new provision.
Okay, that takes care of the questions. The Representative Hillstrom moves the A15 amendment. All in favor, say aye.
Aye.
Opposed? No. Motion fails. Representative Becker-Finn, A16.
Thank you, Mr. Chair. So the A16 amendment would provide funding for a grant for legal representation of children. It's essentially Representative O'Neill's bill, House File 1252. If you remember, we had testimony from the Children's Law Center, and Representative Crecia also had a bill regarding telling children that they have this right and giving them the opportunity to act on this right. And so the Children's Law Center is an organization, if folks remember, that it currently is providing that legal representation, but they do not have the funds to provide representation to the degree of how many children would potentially do have the right to this legal representation. And so I find it interesting that in the bill we have, we did include Representative Krisha's bill, House File 1702, which is on page 15 of the DE3 version of the bill, which is great. And so we're now requiring that folks in the system let kids know that, you know, children 10 and over, that they have this legal right to representation. But we did not fund an organization that would actually help that happen. So we're now in a position where more kids will be aware that they have this right, but we didn't include, currently there are not the funds to do that, to make it a reality. So just that's what this amendment does. Again, it's essentially Representative O'Neill's House File 1252.
Any questions, members? The chair would ask for a no vote on this one. Not only the MinCor fund, but there was some controversy about whether we should provide funds and how much to another organization that seems to have their needs taken care of by others. So, all in favor say aye.
Aye.
Opposed? No. Motion fails. Okay, Representative Zerwas, you want to explain your amendment and move it?
Mr. Chair, members, I'd like to move the A17 amendment. The A17 amendment are parts of the prison segregation reform bill that I introduced and had heard. This is this amendment includes portions of the bill that, from the best that we can tell, won't incur a cost to the Department of Corrections. Subdivision 1 provides authorization for the Commissioner of Corrections to use segregation, which oddly enough isn't in state law. Subdivision 2 is minimum conditions for segregated housing. Subdivision 3 is a review of disciplinary segregation status, saying that if someone is in segregation, we need to review why they're there and if it's appropriate for them to be there, and it upticks up to the commissioner for the length of time that they're in there. Subdivision 4 reinforces graduated disciplinary sanctions. Subdivision 5 addresses discharge from segregated housing and the concern that we had around that. And then subdivision 6 is some reporting. Members, this comes after a series of articles done by the Star Tribune that I think many members of the legislature were pretty surprised at some of the stories that were related from the lengths of time and some conditions within segregation units within our state Department of Corrections facilities. I hope this is the beginning of the discussion and the dialogue. I've worked extremely closely with both NAMI and the Commissioner of Corrections as we've talked about some language that people can agree on as we start. I know the Department of Corrections is bringing in some consultants, I think the Aveo Institute and others, to look at different policies and procedures. I understand that the department wants to handle a lot of this just under department policies and regulations. But quite frankly, I think when we're talking about taking away the most freedom that we can possibly take away from someone in the state of Minnesota by taking someone that's already incarcerated and then putting them into segregation, I think that calls for a little bit higher than an SOP manual and a policy and a procedure. I think we need to start looking at state statutes that govern how we handle this. And this is my first attempt at trying to do that.
Representatives Considine and Hillstrom.
Thank you, Mr. Chair. It occurs to me that maybe we should go see one of these segregation units. I'm guessing there's not a single person here that has actually seen one.
I have.
When? Oh, no, okay. When were you in, Representative Zerwas?
Never in SEG. Never in SEG. We toured.
I was just, again, was going to suggest that maybe we go to one of the facilities and see them. There was a Sergeant Kyle from Shakopee that was here and issued that invitation. Turns out there's a lot more people who've seen it than I thought.
And then our next stop would be at the hospital to visit the guards that have been injured by these people that have been in segregation. Representative Hillstrom.
Thank you, Mr. Chair, and Representative Zerwas. I think that the testimony we've heard from the Department of Corrections is they don't have opposition to the legislature weighing in and placing rules on what segregation should be, but they do ask that we fund the guards appropriately so that they actually can safely do that. I'd note that I offered an amendment to add additional correction officers, which failed, and now there is information that's going to be placed in this bill that's going to make folks feel good that they're doing something about segregation without actually doing something about segregation. Members, I am a prosecutor. I have prosecuted inmates who have assaulted guards while they are on duty. It is serious, and the consequences to the inmates who are placed in segregation for long periods of time is very serious as well. I think that it is wrong to put things in the bill, that language that doesn't actually go anywhere near fixing the problem that we have. I think the Commissioner of Corrections has made it very clear that they're happy to work with us on the language and what the right thing to do is, as long as we pay for it. You don't get to give it lip service without actually doing something. So I wish that the A14 amendment had been passed. I am sorry to see that the language that's being added is just merely lip service and not actually funding. It's pretty difficult to add the additional officers that you need to keep folks safe, to give inmates the time out of the cell that they need without actually providing the officers that they say you already need. So while I support doing something about segregation, I actually support paying for it, not just saying I support it.
Representative Dean and Representative Pinto.
Thank you, Mr. Chair, and I'm not sure if procedurally I can do this, but should we pass this, Representative Zerwas, would you be willing to reconsider us voting down A14 to take it up for reconsideration?
Mr. Chair and members, we've worked really hard with this language here with all stakeholders. I wasn't involved with the A14 amendment. The chair asked that we not adopt the A14 amendment, and I would stick with the chair.
Representative Pinto.
Thank you, Mr. Chair. So I guess I'm finding it a little hard to believe that there wouldn't be an additional cost to the department. I wonder if the commissioner can just comment on whether he thinks there'd be a cost to this. I'm just because
You would like to come down and answer Representative.
well, I don't mean, or someone from the department. Didn't mean to call you out, Commissioner, in particular, but
Easy. Welcome, Commissioner, again, and you want to restate the question, Representative?
Thank you, Mr. Chair. I guess the question is, Representative Zerwas indicated that he thought that there wouldn't be a cost, and I want to emphasize, of course, I'm supportive of addressing the concerns about restrictive housing, and I appreciate Representative Zerwas pursuing it, but the problem is that, as has been alluded to with the other questioners, if we impose rules but then don't provide funding, it's this unfunded mandate once again. And so I guess I'm just wondering about having the commissioner comment on the idea that this particular provision wouldn't require additional funding.
Commissioner.
Mr. Chair, Representative Pinto, as you know, we've been working on this for a couple of years, and in formulating the budget for the governor, we did add $3.15 million for mental health services enhancement and $3.7 million for restrictive housing reform, with the recognition that if we are engaged in really making a difference in these strategies, it is very staff intensive. We did work with the author and some advocates to get the language to be livable at this point. This language steps in the right direction, but if we are really serious about doing the best we possibly can for this population, then we have to enhance mental health staff and security staff that helps in this effort as well.
Mr. Chair,
Representative Pino.
I guess what I'm gathering from that is that there may be a marginal cost increase because of this, that the department, and I guess let's recognize then the department would be absorbing that out of other needs. And I understand, I guess what I'm hearing from you, Commissioner, is you're supportive enough of moving in this direction that you're willing to absorb that, recognizing that that's a real, that at some point we're going to have to put some funds to even to fully implement this, much less go forward. But please, do you comment on that?
Mr. Chair, Representative Pinto,
Commissioner.
this existing, or this proposed language does increase workloads, and certainly the review process is condensed, and that puts a burden on our staff to review these cases more frequently. It's doable. The main cost item in the existing proposal here is the data management system, or to report to you folks on an annual basis, not only the numbers going in and the numbers coming out, but a new item which talks about why somebody was not given their 5 hours a week out. And anything that collects data in government these days costs money, and if you recall, we are bringing in the consultant, DeVera folks, and one of the things that they are going to give us assistance on is developing an information system that will report to you folks.
And Mr. Chair and Commissioner, I feel like especially the comment the chair made before about how the need to tour a hospital because of threats to guards, et cetera. If people are out of the cell more, this says 5 hours a week, it's et cetera. I guess to my mind that ties in very very directly with the need to have then increased guards. In that way, this really would require increased staffing, even this provision. So if you could finally comment on that, that'll be my last question to the witness, Mr. Chair.
Commissioner.
Mr. Chair, Representative Pino, the time out of cell is an important item related to this initiative. And the infrastructure, and the following question is, what do you do with that time out of cell? And we would prefer to do treatment, get people better before they go back into general population. Some of these folks, these are basically the worst of the worst, and they continue to present themselves in terrible ways. Representative Cornish mentioned the assaults on staff, and we are very concerned about that. I looked at a tape yesterday from a previous assault, and it was a brutal minute-long attack on a corrections officer. And we know that that person is going to go back in general population, but we want to do the absolute best we can. And again, that takes mental health staff and security staff.
Okay. And so, Mr. Chair, I guess just thank you, Mr. Chair. So just a comment on this. I mean, I won't have the commissioner say this, but the letter that he provided points out that no fund, this is talking about restrictive housing, no funding, when we don't provide funding, which we're not, means that these offenders are going to return to the general population without programming to address the very behavior that caused them to be sent to restrictive housing. So I feel like this is an example, as was Representative Becker-Finn's comment about representation for children, et cetera. We can't get something for nothing. If we want to achieve, there are certain goals that are going to cost something to do, and I recognize that we're under a constraint because of the targets that this committee was given. So again, I appreciate very much Representative Zerwas's push on this, and I appreciate what the commissioner had to say about the amendment. And that's helpful, but I guess it does seem to me that at some point we need to provide funds to back up these reforms that are being pushed. Thank you, Mr. Chair and members.
Representative Zerwas.
All right, thank you, Mr. Chair and members, and I hope you understand the challenge that I am in working on this issue particularly. I know targets are what they are, and I don't get to make the targets. I don't get to decide on the targets. I get to put forward bills and amendments and work with the commissioner and his staff, and I have to say that the commissioner has been, and his staff have been fantastic to work with. This is something that we started talking about before session started and have been working on together along with representatives from NAMI throughout the entire session. I expect that this is one of those issues that for the remainder of the time that I'm at the Capitol will be something that I work on each and every year. I think there's a huge issue within our correction system as a whole, starting at county jails and going up through of having people that are in correctional facilities that it probably isn't the best place for them to be. That being said, if it was someone with diabetes, that was low blood sugar, that was having behavior issues, if it was someone with heart disease or cancer or a brain tumor, and they're having behavior issues, make no mistake about it, we would not lock those people up for 200, 300, 400, 600 days at a time. We wouldn't. We just wouldn't treat them like that. And so this is the first step. I'm not saying I have all the answers. I'm not saying I can fix it. I'm telling you this is the first step. This is what I can get in this bill. That's why we're here. Mr. Chair, with that, I'll call the roll and ask for a roll call.
Okay, any other questions? Seeing none. Representative Hilton.
Thank you, Mr. Chair, and Representative Zerwas, with your commitment that you'll continue to work on it, and maybe between now and the floor, we can find some money, maybe in Ways and Means or something together. I'll support your proposal, but yeah. But I do serve on Ways and Means, Representative Zerwas, and I hear that you care very much about it, and maybe we can actually find some money to do the right thing.
Okay, the clerk will take the roll.
Representative Cornish.
Aye.
Representative Johnson.
Aye.
Representative Hillstrom.
Aye.
Representative Becker-Finn.
Aye.
Representative Considine. Representative Dean.
Yes.
Representative Frankie.
Aye.
Representative Grossel.
Aye.
Representative Howe.
Aye.
Representative Lomer.
Aye.
Representative Lucero.
Yes.
Representative Newberger.
Aye.
Representative O'Neill.
Yes.
Representative Pinto.
Yes.
Representative Ward.
Yes.
Representative Zerwas.
Aye.
The vote being 15 ayes, the motion passes. Okay, Representative Ward, A19, we want to move your amendment?
Thank you, Mr. Chair. Yes, I'd like to move my amendment, A19.
Okay, Representative,
No.
Representative Ward moves the A19 amendment. Did you want to speak to it?
Yes, please.
Oh, go ahead.
Thank you. Thank you, Mr. Chair. We've had quite a bit of testimony on youth intervention programs, and with all respect to the challenges of a budget creation for this committee, I'd like to point out a few things for us to consider. With community-based based approaches, youth intervention reverses the growth of state government, the outcome of self-sufficient adults who are not going to end up in our prisons is an important consideration. It works. Youth do better in school. They improve their life skills, develop pro-social attitudes, and don't get in trouble again. We get our money back about tenfold for every dollar that we put in youth intervention programs. We have funded it at the same level that it has been, but we still have about 300,000 youth identified at risk in this state who will not receive services. This is mental health, addiction, and other issues that young people face and lead them into trouble. Without this kind of intervention, we end up treating or putting youth into other programs. Residential treatment costs about $75,000 a year. Group homes cost about $56,000 a year. Juvenile correctional facilities are $40,000 a year. This is per youth. And just a juvenile court case is about $3,500. So we can save a lot of money, keep kids out of trouble, and keep them out of prisons. Public safety agencies, police, sheriffs, the Juvenile Officers Association, and others support funding, increased funding for these programs. So I'm taking the money, suggesting that instead of looking at creating a private prison, that we use that money instead. It's not nearly enough, but it would go a ways to supporting our youth intervention programs. And I would appreciate it if we would consider that. But, Mr. Chair, I'll withdraw the amendment.
Okay, thank you, Representative Ward. Representative Ward withdraws the A19 amendment. Representative Dean, the A26 amendment.
Thank you, Mr. Chair. I've sort of been getting a sense of how this meeting is going, and anything we're offering is going to be shot down. But I did want to make a few comments about the UCC in looking at Collateral Consequences Act. Something that's really, really important. There are oftentimes individuals that enter the criminal justice system that are looking just at what's in front of them when they're bargaining or when they're negotiating a plea deal or something of that nature, and often don't understand the length of what their decisions are going to mean for them for sometimes the rest of their lives. I think we really need to start being honest with people that when you do, one, commit a crime, or two, when you plead to something, that oftentimes there are consequences beyond that moment when you're looking at that. And I know there are some people say, well, you know, if you're going to commit a crime, well, that's your issue. But oftentimes there are, you know, prosecutors sitting next to the minority here that, you know, will sort of use the situation in a way to get someone to plead to something, because quite frankly, we're finding out that there's not money for people within the criminal justice system, attorneys, public defenders, and everybody to sort of handle all of their caseloads. So sometimes some of these things get down to doing what is expedient, maybe not what is 100% right. But given the way this this committee hearing is going today, Mr. Chair, I'd like to withdraw the amendment.
Okay, Representative Dean moves the A26 amendment. The only problem that was, oh, you withdrew it, I'm sorry.
Yeah.
I'm not even going to make a comment then.
Okay.
Save me some breath. Thank you, Representative Dean. But I would like to work with you on that for next year. I don't see it as a bad amendment, it's just in proper timing, so. The Representative Ward A27 amendment.
Thank you, Mr. Chair. This uses the Appleton money again to address Representative O'Neill's alternatives to incarceration. And we need to fund this, so I would suggest that I'd like a roll call on this, and happy to answer questions.
Representative Hillstrom.
Thank you, Mr. Chair. Members, I would encourage you to support the A27 amendment. Representative O'Neill has an idea about how we can deal with some of the challenges that we have in our prison system. We have heard from the Department of Corrections that 50% of the inmates cycle in and out of our prison in a year. 50% of the population. Representative O'Neill had a bill that allows, instead of someone immediately being sent back to prison if they get out for a technical violation, that they can do some alternatives to incarceration, whether it's treatment or other needs being addressed in the community. I think that is a better investment. I think that if we actually want to get serious about the prison population that we have in Minnesota and the cost, we need to get to the underlying items that cause criminal activity. We know chemical dependency is a strong one, and that is one of the things that we can do is make certain that folks have access to a chemical dependency treatment. So I don't think we should be doing the Appleton prison, and I would much rather see the money go to alternatives.
Representative O'Neill.
Thank you, Mr. Chair. And I do thank both of you for bringing this forward. It was a bill that I worked with Minnesota Adult and Teen Challenge and RS Eden and DOC, and worked really hard on thinking outside the box. And we don't get to do that as much as we'd like to here at the legislature, and it was a real pleasure to be able to do that. And I think the most satisfying thing was to hear the Commissioner Roy come up and say that this could be so effective that maybe we don't even need another prison, which would be fantastic. That would be ideal. And just some of the statistics that you had pointed out, it's important to remember, too, that in 2016, out of the 8,037 that were admitted into the prison, 64% of them were because of technical violations. That means only 34% were actually committing a new crime. So it is a serious problem. It's a serious issue. And of course, some of the technical violations probably are serious as well, but at least this gives an alternative that if they're amenable to a restructure, if they're not going to be posing a danger to society, because we don't want folks that are dangerous, obviously, out among us. We want them getting help and getting away, right? So in prison so that they can be safe and we can be safe. But I think this is a really great, out of this entire bill, and maybe I'm biased because it's my part of it, but I think it's one of the greatest reforms that we've done in this bill. And I appreciate you recognizing that. I do ask that we, I know you have a roll call on it, and it's a tough roll call, obviously, but I ask that you reconsider the roll call because we're really looking at trying to fund this to a higher level. And if you would work with me, maybe we can work on some of those things and try to figure out some shifting and some funding that we can get at. But I appreciate the amendment. I appreciate the effort. I appreciate, most of all, the acknowledgement that this is a really great reform and maybe the best reform that's in the bill. So thank you.
Representative Ward.
Thank you, Mr. Chair. We're talking about systemic reform, and systemic reform is needed rather than another prison. We have set the system up so that people can easily fail, and we can address that with this amendment, and I'd appreciate your support. Thank you.
Okay, Representative Ward has asked for a roll call. The chair would appreciate a no vote. The clerk will take the roll.
Representative Cornish.
No.
Representative Johnson.
No.
Representative Hillstrom.
Aye.
Representative Becker-Finn.
Aye.
Representative Constein.
Aye.
Representative Dean.
Yes.
Representative Frankie.
No.
Representative Grossel.
No.
Representative Howe.
Nay.
Representative Lomer.
No.
Representative Lucero.
No.
Representative Newberger.
No.
Representative O'Neill. Representative Pinto.
Yes.
Representative Ward.
Yes.
Representative Zerwas.
No.
Six ayes, 10 nays, the motion failed. Okay, Representative Pinto, the A29.
Thank you, Mr. Chair. Mr. Chair and members, Judge Larry Cohen was the first person to be mayor of St. Paul, chair of the county board, and the chief judge of the judicial district. A group of citizens are trying to put together a memorial that would recognize him at the courthouse. I'm withdrawing the amendment, but I'm hopeful on behalf of those citizens that there might be some other solution that may be found, both to recognize him, but also to recognize some of the folks who contributed so greatly to our judiciary. So I'm withdrawing the amendment, Mr. Chair. Thank you.
Representative Pinto withdraws the A29 amendment. A31, our last amendment that I know of, for Representative Ward.
Thank you, Mr. Chair. I'm going to bring youth intervention programs back up again because we really need to, again, address a systemic issue. Youth intervention programs are a reform. They're rethinking government. It's an effort to solve unsustainable problems. Breaks the cycle of generational demand for public services. Reduces crime and improves public safety. Corrections is a large bureaucratic institution, and youth intervention supports community-based solutions, provides local control to communities to solve their own problems rather than government. Youth intervention saves money. In the short term, by letting police proactively patrol, and long term, by reducing the number of adults needing services. I would, with the help of adults, and the state may or may not incur costs 1, 2, 3, 5, 10 years down the road, but with the help that we're providing in youth intervention programs, youth can become productive public servants and contributors to the common good. I'm asking that this money be taken from MNCOR and to fully fund the request of the youth intervention programs. But I agree with others, as the votes on this committee are going with the amendments, I withdraw the proposal.
Okay, the amendment is withdrawn. Now we have testifiers that have signed up, and let me read the names off of them. There's Commissioner Tom Roy, Chief Judge Joanne Turner, State Fire Chief B.J. Jungman, Association of Minnesota Emergency Managers Rick Larkin, Cassandra O'Hearn, the Deputy Commissioner DPS, and Bob Small from the Minnesota County Attorneys Association. If you can be ready to come up in that order, Mr. Roy, Commissioner, would you like to give us your thoughts?
Mr. Chair, representatives, I just want to follow up on a couple items from last week. I think with some important information as you work on this bill. Representative O'Neill asked about the impact of the drug reform, the bed impact. And in May of 16, the Sentencing Guidelines Commission did do a bed impact statement, 11-page document, and I will just read the first 5 years. Fiscal year 17, 108 beds. Fiscal year 18, 276 additional beds. I'm sorry, that would not be additional beds, that would be total beds. That would be building on the 108. 19, 388, and 20, 459. Those bed savings were built into our capacity projections, and Representative Johnson, during the last hearing, you had some concerns about the varying numbers that some of the projections that you've seen have, I think you characterized them as wild projections, or they were, it's been reported different ways at different times. I have provided all the committee members with a chart that you should have in front of you. We have high confidence in these numbers. The red line across the top of the bar is the actual beds in prison, and additionally those that are serving time on our work release program, which also are commitments to the Commissioner of Corrections. So you can see the capacity of those two items at 9,739. The red row at the bottom, those are the numbers, that's the gap in need, the projected population overage. So 4 years out, we will be 300 beds short, 294. And I had some reluctance at the last committee to go a decade out, but we're pretty confident that if statutes don't change, these are pretty good numbers. Also, I think it's important for the committee to remember that some of these reforms just started in this past year, and we aren't realizing the full fruit of our efforts. We've modified our violator return policies. We are encouraging our county partners to use local resources for violators as much as they possibly can. And in our budget request also that is really needing support is the support of local corrections. Our county partners are very, very important. And the investment in those probation and parole services to our county partners is something that will prevent prison beds in the future. So thank you, Mr. Chair. Thank you, committee members. I will sit for questions, though I have sat here a lot today.
Members, questions for the commissioner or staff?
Thank you, Mr. Chair.
Okay, thank you. Chief Judge Joanne Turner, the tax court. Go ahead, ma'am.
Good afternoon,
Your Honor.
Mr. Chairman, members of the committee. As you know, I'm Joanne Turner, Chief Judge of the Minnesota Tax Court. I want to talk to you specifically about the chairman's decision not to fund implementation of our case management system. As you may recall, our existing case management system was purchased in 1999, last updated in 2002. We are weeks away from going live with the new system. Even as we speak, at 3:30 this afternoon, I have another meeting on configuration. The ask in the budget for implementing it and allowing us to turn the thing on June 30th is $400,000. I'm assuming that the chairman's decision not to fund it in this proposal is because of the size of the allocation. But I want to make you aware of something. To the extent that the chair expects the court to absorb the additional cost of the case management system, and let me just explain what that cost is. We have to pay an annual maintenance fee, which is about $100,000. We have to pay to store the data that's in the system, and that's about another $100,000. Minute wants us to fund a half-time person with the technical ability to solve problems with the system once it's up and running. That's all about $400,000. On a budget of about 1.392 base, absorbing that $400,000, not really in the cards. And to the extent that we can, it would come because of salary savings. And to that point, whether you may or may not know it, there's a provision in the state government finance omnibus bill that would bar state agencies from doing that going forward. It's Section 60, Article 2, House File 691, and it says, to the extent that an executive branch agency accrues savings in personnel costs resulting from the departure of an agency employee or the maintenance of a vacant position, those savings may only be used to support a new employee in that position at an equal or lesser rate of compensation and for a equal or lesser full-time equivalent work status. Savings accrued from departed personnel or maintenance of a vacant position may not be transferred or reallocated to another program or activity within the executive branch agency or used to increase the number of full-time equivalent employees at the agency unless expressly authorized by law. Now, we can debate the chances of that bill surviving. We can debate the chances that that provision survives going forward, but if there's any chance of it at all, and to the extent that, Mr. Chairman, you or the committee is relying on us being able to fund the system through salary savings, that's a huge gamble. If we can't turn the system on June 30th, the state will void the contract with Thomson Reuters. We'll have to live with the system we have for another 2 years. And 2 years from now, I'll be back, or my successor will be back, asking for funds to issue another RFP, and we will wait another 2 years after that to implement a system. And in the meantime, the state will have paid hundreds of thousands of dollars for a system it can't turn on, and we will have spent thousands of hours to implement a system we can't use. So I understand the budget constraints you've got, Mr. Chairman. I hope that what I've told you today will give you the leverage you need to increase your target so that we can get our system up and running on June 30th, so that we can take advantage of it, and more importantly, so that taxpayers can take advantage of it. Thank you so much for your time and attention.
Your Honor, could you explain, and maybe I'm not understanding right, but did you commit to an expense in the future that you didn't know if you'd have the money or not, and yet you talked about you wouldn't be able to turn it on because you wouldn't have enough money for did you pre-contract this before you knew what your budget was? Or just explain that better to me. That's the way it looked.
Mr. Chairman, the contract does allow the state to terminate it at any time for lack of funding. But we have to pay an ongoing maintenance fee. We did not buy the system outright. That's not the decision that the Department of Administration made.
Okay, but you.
So we have to pay a license fee, like you do for any software, and we have to pay to store the data. That's not an expense I can prepay. As I understand it, the state has not committed irreparably or irretrievably to spend the money, and the contract can be terminated if no funds are appropriated. That's my biggest problem, that the contract is terminated because no funds are appropriated.
Okay, but we funded your request 2 years ago.
That was to acquire, I'm sorry, I'm tired. That is not the total cost of the system ongoing. That was clear. There was money in the tail for it. There was money in the tails for it. But at the time that estimate was made, we didn't know who the vendor was that Department of Administration would select, nor did we know what the package would be. So Minute made a good faith estimate of the tail, but the estimate of the tail is not enough.
Minute. Okay, we'll look at this and examine the problem here as we go on.
I'm happy to provide you with any additional information you might need, Mr. Chairman, and we do appreciate your consideration.
Okay, thank you, Your
Thank you
Honor.
so much.
Appreciate it. Any questions? If none, Mr. Jungman from the State Fire Chiefs Association.
Good afternoon, Chair Cornish and committee members. I am BJ Jungman. I'm the fire chief for the city of Burnsville, and I'm here on behalf of the Minnesota Fire Association Coalition, which is comprised of 4 state fire organizations, the State Fire Chiefs Association, the Fire Department Association, Fire Marshal Association, and the Arson Investigators. Thanks for taking my testimony. I'd like to thank you for the following Fire Service Advisory Committee recommendations for the fully funding the State Fire Marshal's Office and the Minnesota Board of Firefighter Training and Education. I am, although, disappointed in the funding of the hazmat emergency response teams. House File 1179 proposed funding 3 ERT teams from the general fund. The bill now funds 4 ERT teams from the fire safety account. We are concerned about the process that this funding took, as it did not follow the process of getting vetted through the Fire Service Advisory Committee that has all of the stakeholders represented. This now creates a new way to fund individual initiatives that circumvents the current system, and we are concerned additional initiatives will follow this new process. This really comes down to a process issue and not a worthiness issue, in our opinion. We'd recommend that all funding requests follow the designated process through the Fire Service Advisory Committee. We look forward to working with you on the issue during conference committee, and I thank you for your time today.
Hey, another testifier or not? Okay.
Time for the next one.
I just wanted to make it clear that since we put this new formula in a number of sessions ago, and I was here a long time ago, we've been very kind to the fire service and give them millions of dollars worth of money that they almost had to look for training for, and we hope you appreciate that. Some of this, and I'll get to Representative Newberger, comes from some, I don't know, quarreling or whatever within your own group that you have to figure out, and come to us much earlier with these requests so that we can figure them out between the different ERT teams and things like this, because we had several people pop up this year that we didn't know about. So we look forward to working with the fire service and with all you folks and coordinate a much better product here in the future with more communication and warning what's going on. So Representative Newberger.
Thank you, Mr. Chair. I would like to thank you for the funding for these teams. The testifier said that this was a worthiness issue. If you live by the railroad tracks, it is definitely a worthiness issue. I have a district that is, the spine of my district is the Burlington Northern Rail Line. Just about every major city, including St. Cloud, which my district arcs around, which has about 75,000 people, is really close to these tracks. I myself live 3/4 of a mile from the railroad tracks, and as you know, a unit train, 110 cars with Bakken crude, that's a disaster bar none. And just one of those cars, if it explodes in this post 9/11 world, has a trajectory up to 3/4 to a mile. You multiply that by 110. With all due respect, Chief, this is a worthiness issue. Now, I have worked with the stakeholders the four cities that are involved here. And all four of them have pledged to me that they are going to work together independently and together with the folks that you're with to straighten this out. The timelines don't line up. We need these ERTs, and to say that this is a worthiness issue, I take exception to that, because it is.
Response, go ahead.
Chair Cornish and Representative Newberg, I don't know if I misspoke. I meant to say it's a process issue, not a worthiness issue, is what, I'm not sure if I misspoke or.
I'm good, thank you.
Oh, okay. We'll work on that process. It does seem kind of complicated to some of our members and the flow chart that we looked at, so. Representative Hilstrom.
Thank you, Mr. Chair. And Representative Newberger, I don't disagree with you. I think that these teams are very worthy. However, in this bill, we repeal the very fee that we charge to railroads to pay for emergency management kinds of situations. And so one way to fund the needs based on the dangers of railroads is to actually keep the assessment that is current law.
And that might not have been a bad idea, but that's not what the bill said. It's sunset. All we did is didn't continue it. And it has to be an agreement. They made an agreement, and they stuck to it for 2 years, and the railroad wasn't interested in keeping the agreement. Representative Hilstrom.
Thank you, Mr. Chair. And I don't mean to debate you on it, but that certainly would have been a revenue source to deal with some of the challenges that you have based on the target that you got. And so between now and the next committee or the floor, there should be some conversations about what the right thing to do with that assessment is.
Anybody else? Representative Considine.
Again, not wanting to start an argument, but that is what the fund says. It's for railroad safety, and these problems that are coming up are directly attributable to the railroads doing business in Minnesota. So I'm real comfortable with not sunsetting it and allowing these ERT teams to be funded for it. I'd like to see one in Mankato at some point. We get a lot of trains going through there.
I don't consider this an argument. It's a good discussion.
Oh, okay, good.
But, you remember
well, I mean,
remember how they did it, though? They came to the table. Nobody knew what they were going to do. All of a sudden, they decided on their own that they're going to keep this agreement growing, take money from the railroads, and the railroads didn't even hear about it, and they were going to slip it through on us, and only because I caught it, thinking there was a sunset in there. So if they want to do that, they've got to let us know ahead of time, make a bill, and then maybe talk about it, because the railroad was getting railroaded.
The term railroading comes from the way they do business. And as a member of the city council on Mankato, we tried for 10 years to get them to even talk to us, and they just don't do it. So I'm guessing if we didn't sunset this, they might actually come and talk to us.
Oh, we'll bring a bill next time. Okay, Mr. Larkin from the Minnesota Emergency Managers.
Thank you, Mr. Chair. I'm not sure I was wise to sit up here to save time, but the Association of Minnesota Emergency Managers thanks you, Mr. Chair, and a kind of Captain Obvious statement is we recognize that you have a really hard job and members of the committee in terms of targets and the political process and all of that. So we just want to offer our respect and our appreciation for the changes made to the disaster assistance account. As you know, in 2014, we created that disaster assistance account. We do have concerns, though, with the level of funding. The $2 million appropriation called for in the public safety budget is concerning because we have had just 16 events in the last year. In 2009. 2016, we've had 9 events. Let me get that right. Those $8 million are very much on the thin margin of safety for local communities to get their funds following a disaster without the need for a special session. So while we're appreciative of the changes to include public utility co-ops, the added number of eligible applicants is concerning because of the lack of commensurate funding. The second thing that I'd like to bring up, Mr. Chair, is a very significant concern regarding, unfortunately, for your discussion, the specialty response teams for the bomb squads. The governor's request was $100,000 additional. The Department of Public Safety had a commissioned study from the management and administration, and that study noted that 294 responses out of the 318 total specialty team responses were conducted by the bomb squads, 4 of those bomb squads in the state of Minnesota. That study in September recommended increased funding and noted that only 5% of the funding allocated for specialty response is allocated to the 4 bomb squads that cover the entire state of Minnesota. In 2001, Public Safety Report on Preparedness for Terrorism recommended $341,000 per year for adequate bomb squad coverage for the state of Minnesota. So we're very concerned as emergency managers throughout the entire state that there are 4 teams, and that we've requested time after time additional funding in under the auspices of these previous studies. Now we have 2 in the books, and we have not adequate funding. At the end of this month, 2 of those 4 bomb squads will be out of reimbursement dollars for state response. They will still continue to respond because they're public safety professionals. But it illustrates the urgent need, and that's the study language, an urgent concern, striking disparities, and gaps in funding for bomb squads. So while we appreciate your horrible predicament of targets and difficulty in meeting those targets, we do appreciate you changing the disaster assistance account eligibility. We do appreciate the $2 million. We're concerned that it's not enough, so if potentially during your negotiations you're able to find additional resources for the disaster assistance account, I think that would serve local communities the best. And it's important to note that in 2016 there were 35 communities, as you heard a couple of weeks ago from my past president, John Bowen from Crow Wing County. It's important to note that all 35 communities in 2016 that received disaster assistance funding were non-metro counties. Non-metro counties. So that disaster assistance account is working. We appreciate the funding. We're concerned that it's going to be adequate, and we're concerned about the longevity of the bomb squad response capability.
Thank you, sir. Questions? Okay, thanks for your testimony.
Thank you, sir.
Cassandra O'Hearn, Deputy Commissioner, DPS. Welcome.
Thank you, Mr. Chair. Members of the committee, my name is Cassandra O'Hearn. I'm the Deputy Commissioner at the Department of Public Safety. First, I want to acknowledge and thank you for your support of the work that we do at the department. I respect and appreciate the difficult decisions you are faced with as you work on this budget. Fully understand that there are compelling and competing interests for funding. We have provided you with a letter that explains in more detail our concerns with this bill. Public safety is one of government's core functions. Keeping the people of Minnesota safe is our core mission, and although we are a state agency, our impact is local. We assist our public safety partners across the state as we respond to the needs of the people who you represent. Governor Dayton's proposal reflects our priorities, and I hope that you will reconsider and fully fund our budget proposals. These strategic investments support the communities you represent and the ones that we serve. It is money well spent to keep Minnesotans safe. Representative Cornish, thank you for fully funding our request to replace the predatory offender registration system, increase the BCA's drug chemistry lab staff, and provide funding to support the current level of operations in the department. This funding supports critical public safety functions, and we appreciate your support. However, I am asking that you fully fund the following proposals that support our shared mission with our criminal justice partners and help us to meet our obligations to all Minnesotans. The requests for the BCA's assistance in complex homicide and narcotics investigations have been rising. The BCA leads these large-scale complex investigations at the request of local law enforcement agencies. Failure to fund the request for additional agents will jeopardize our ability to assist local communities across the state when they need us most. Our Alcohol and Gambling Enforcement Division has seen a dramatic growth in the number of liquor licenses they issue and the premises they must inspect, all without any increase in staff. We need 2 additional field agents to properly perform this work and meet our statutory obligations. Additionally, we request funding for the liquor liaison educator position to continue the valuable services for cities and counties. To address firearms examination processing time concerns, our proposal included an investment of 2 additional firearms analysts. We are in need of funding for ongoing system maintenance and support of the new criminal history system. This is a critical backbone system for providing criminal justice partners with up-to-date and accurate information. Our request included an additional BCA analyst to bolster the work of combating the current drug threat and opioid epidemic facing Minnesota. Additional proposals increase our support of local communities by replenishing the disaster contingency account to ensure that resources are available quickly for those communities affected by disasters. Increasing the reimbursement to the 4 law enforcement jurisdictions who provide bomb disposal services outside of their regular service areas. Increasing funding for the multi-jurisdictional violent crime enforcement teams. Removal of the sunset on the rail and pipeline safety account, and funding for Roseau County's flood mitigation efforts. I ask that you reconsider and fully fund our budget proposals. Thank you again for hearing our concerns, and thank you for your ongoing support of public safety in Minnesota.
Thank you very much. Any questions? Okay, thanks again.
Thank you.
And our last, best for last here, huh? Bob Small, our Executive Director of the County Attorney's Association.
Well, thank you very much, Mr. Chair. Good morning, or good afternoon, everyone. My name is Robert Small. I am the Executive Director of the County Attorney's Association. I'd like to address that part of the bill that deals with the Community Justice Reinvestment Account. As the chair knows, and many of you that were here last session knows, that the county attorney's efforts around drug sentencing last session was our top priority. And as part of that was the Community Justice Reinvestment Account component. As you heard from Commissioner Roy earlier, the impact of the drug sentencing reform is already occurring, and there is a need for funding in the community for the community justice reinvestment piece in the current biennium to assure there are adequate resources to provide the appropriate treatment and community supervision for these offenders. The Department of Public Safety received over $2 million in requests for this activity in its first solicitation, and there is only just shy of $500,000 in the base. As a result, we hope that the chair will reconsider delaying the appropriation until the next biennium, and we look forward to working with you on that. Thank you very much. Let's have lunch.
Questions from members? Thank you very much.
Thank you very much.
Small. Any questions from members? Representative Hillstrom.
Thank you, Mr. Chair. These aren't questions, but these are comments on the bill if you're ready for finishing comments. I wasn't certain if there was any other testimony, Mr. Chair. Mr. Chair, we currently have a $1.65 billion budget surplus, and the budget targets that this committee received were because there's a $1.3 billion tax bill. We're going to be debating that tax bill on the House floor maybe as early as tomorrow. We saw it in Ways and Means last night. This legislature is making a choice about where to invest its money, and public safety has always been one of the committees that has been bipartisan. Mr. Chair, you have a better target than the Senate has, I'll give you that, and you did quite a job in not making cuts to the areas of public safety that we have within our jurisdiction. However, many of the requests for issues that we would agree on that are important to public safety were not able to be funded with the budget target that this committee received. I believe that things like the bomb squad are very important. We didn't have the money to fund that in this bill. I believe that the governor's recommendation for the disaster relief fund are very important, and I know, Mr. Chair, that you have had a long history of funding those kinds of issues. I would have rather seen some of the amendments that we offered be adopted to deal with the issue of corrections and probation officers. There are some policy provisions that I wish were not in this bill. As you know, I've been someone who has spoken out regularly about the use of private prisons in this state. So most of the folks that have testified on this proposal have said, thank you for the money that we get, but we wish we had more, is pretty much the testimony that we've heard. There hasn't really been any testimony in opposition. I know that we've previously heard significant testimony in opposition to the private prison and significant testimony in opposition to the enhanced penalties for the protesters that are in this bill. Some of the issues that we haven't yet talked about today that are also in this bill is dealing with the issue of the secret sex offenders as we saw them on the news, enhanced penalties for those who possess child pornography, and enhanced penalties for those who commit serious sexual assaults. So most of us are in a position of deciding between some really good things and some really not such good things from our perspective. So, Mr. Chair, you have always had a habit of committing to work with me on the proposals to make these issues bipartisan, and I have no reason to believe that that won't continue. So at this point, Mr. Chair, although there are provisions that we tried to take out and we were unsuccessful, I'll be voting for the proposal in hopes that between now and the General Register, or by the time it goes to the governor, that we can make this public safety bill even more about safety for the public.
Any other comments? Representative Becker-Finn, Representative Becker-Finn.
Thank you, Mr. Chair. Just wanted to reiterate Representative Hillstrom's comments that it really is unfortunate that the target for this committee was so low, and I think, for the public's benefit, the budget targets are not magical numbers. They are choices made by Republican leadership about what the priorities and values are that we want to be supporting, and just wanted to speak to that because I think there are a lot of issues that we do agree on across the aisle and a lot of good things that we weren't able to fund and take care of here. So just wanted to speak to that. Thanks.
Okay, thank you, Representative Becker-Finn. Representative Dean.
Thank you, Mr. Chair, and I'm not going to reiterate what Representative Hillstrom or what Representative Baker-Finn said. There are some good things in this bill. There are some really bad things in this bill. And I would say that there are some things missing in the bill, and I just want to let folks know that I'm not opposed to the good things. I know we might have different definition of what those good things are, but I will not be voting in favor of the bill today. But I hope that maybe before we get to the floor, we can make some changes and make it so that I could vote for it.
Okay. Representative Pinto.
Thank you, Mr. Chair. This may take a little bit longer than my colleagues. I try to speak fairly concisely most of the time, so hopefully you all will forgive me. We addressed the concerns via our amendments about the protest bills, a number of the other provisions, the concern about the Appleton prison, in particular that it would constrain the Department of Corrections. As you may remember, the testifier, who I thought was pretty eloquent, the attorney who said, when you step into a negotiating situation where you tell somebody, I'm going to buy your asset, that just cranks up the price. So I think this is an example of constraining the department in ways that we need to be really careful of. I have great concerns about the sentencing guidelines change. We talked about that by an amendment. We did not talk about the changes proposed by Representative Grossell regarding sex offenses, and I give him such credit for pursuing this, and there's big concerns regarding the situation right now. I do have great concerns that eliminating stays of adjudication, stays of imposition, the way that the bill does, will result in more cases going to trial regarding people who were charged with sexual violence. We may say that's a good thing, cases not being settled. More of those cases that go to trial will result in acquittals. There'll be harder cases. Victims, survivors will have to testify, and those cases will result in somebody being declared innocent, having more acquittals. That means the more of those cases will be dismissed. That means the more of those cases will not be charged. So I have the concern with the language as it is right now that it will actually result in fewer people being held accountable for the sexual violence they perpetrate. The people who are held accountable may well have longer sentences, but some of them who are currently being held accountable to some degree, and we have to get into exactly what degree, won't be held accountable at all. I know, I've spoken with Representative Grossell, I know that his aim is in the right direction, and I know that he's working really hard on this, and I certainly hope that that's an area we can make some progress, because I'm concerned with the language right now that it would have that effect. But the biggest concern that I have, and reflecting my colleagues, and I've seen this in other committees as well, is the budget target. So I want to make sure that folks who are watching understand the way that this works is that the majority decides how much money to spend in certain areas and how much tax cuts to give. So as Representative Hillstrom said, there's a $1.3 billion a series of tax cuts, cuts in estate taxes, cuts in business property taxes that are disproportionately paid by actually out-of-state owners of some really pretty big properties. Instead, then, our committee and others receive these targets that, fortunately for our committee, it's relatively better than some of the others that I've seen. In Health and Human Services, some of us are on. There's a $600 million cut. Representative Zerwas made the comment earlier today that, hey, I don't get to set the target, talking about the restrictive housing. And it's true, individual members don't. But it is a statement of how we collectively are going to be allocating our funds. And when public safety is given the kind of target it was given, certainly those other committees as well, that really puts us in a much more constrained position. It means that positive reforms like addressing restrictive housing, we have to put in some language and not even have the money for it. And you heard the commissioner, the department's going to have to find some money for even the amendment that we all voted in favor of. But larger changes as well, there will not be the funding for. So because there's a $1.3 billion tax cut, the disaster contingency account is not going to be fully funded, or is not going to receive the funding that it should. Because there's a $1.3 billion tax cut, we won't have the funding for guardians ad litem, for the Children's Law Center, the public defenders for kids. We had that bill. We're going to provide notice to kids that they have a public defender, but no increased funding because of that tax cut. Because of the $1.3 billion tax cut, there's insufficient funding in general for public defenders. We addressed that in the amendment. Because of that tax cut, we're going to give, even though we're giving legal aid to low-income farmers, we're not increasing the funding. So that means that low-income folks are going to have to compete against one another for the funding that we have. And because there's that tax cut, we're not going to have that funding for the restrictive housing. That is not directly the sort of the fault, the responsibility of our committee. That's a number that was given to the chair and to the committee within which we're working. But I think it's important to recognize in all the committees that we're on, all the work that we're doing, that this is the result of decisions that are made to prioritize some things over others, and then we're in the position of having folks come to us like the tax court and saying, boy, you know, I don't have the funding to do what I need to do, and there's many other examples, and it's because of the decision that's made at that level. Like Representative Hillstrom, I am very much looking forward to the bill, to there being a continual process of working together on some of the concerns in the bill, some of the policy concerns as well. I hope the negotiations with the governor that the funding is increased in these areas. But I think this is I find this a difficult decision because there's a number of positive aspects of the bill, as well as I know that we've talked about. But boy, when you've got that funding, that target hanging over it, it kind of puts the problem on everything else. So, Mr. Chair, I appreciate the work that you've done in working within that target, but that's a real concern that I have. So thank you, Mr. Chair and members.
Okay, well, at least we know who was elected to give the DFL playbook speech today. So let me tell you, folks, how this really works. One party will complain that the target wasn't big enough at every single session. I've been through about 6 or 7 budget sessions. It doesn't matter if it's a DFL or if it's GOP. You could take this witness list and almost reproduce it. It's the same people, and rightly so. I'm not saying they shouldn't come to us, but very rarely has the DFL chair ever got a target that he or she really liked, and they have to deal with that target. And I can remember a number of DFL chairs sitting up here and catching hell, the same as the GOP did today, for their lack of funding. You didn't give enough FTEs, you didn't fund this, you didn't fund that. But take it for granted, every year we face the people, nobody says we've got enough money, we don't need any more. YIPA, Youth Inventor Program, wonderful program. We've almost doubled their funding, and they're still asking for more, which is your right to do. It's a great program, but we've been very beneficial to that program and others, increased it dramatically, but it doesn't ever seem to be enough. So when your chairman gets a target, it's his or her, like Representative Hillstrom has done before, to sit down and go through, or chairperson, I should say, and go through line by line and decide where the money goes. And anywhere you take it from, they're going to complain when you give it to somebody else. And so that's how the system works. Very rarely do we please everybody, no matter what party it is. But anyway, before ending, I would like to say it's been a hoot. Thank you very much for working. I want to thank all of our staff. I'm not going to mention names because once before I did that, I forgot somebody. And so I just want to thank our hardworking staff that made us look halfway intelligent, and and thank the DFL side and the DFL staff, and for everything that the hard work that we've put into it. So. Representative Hillstrom, did you want to make a comment?
I did, Mr. Chair. I assume, based on your comments, that this is probably the last committee and meeting of the session, and I just want to say that it has been a pleasure to work with members on the committee from both sides. And Mr. Chair, we don't always agree on what issues should be included or not included, but usually we have a spirited debate and ultimately vote on the proposal. So with that, Mr. Chair, it has been a pleasure to work with this committee. Thank you.
Thank you. Any comments or questions from anybody before we renew the motion? We ready? Okay. The chair would move House File 896 as amended to be referred to the general register. Ways and Means first, yeah, Ways and Means. And I think we'll just vote on it. All in favor, say aye. Aye. Opposed?
No.
Aye. All right. Motion prevails, meeting adjourned.